On this week's episode of the Crushing Debt Podcast, 13 myths about Chapter 13.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and this week's episode is based on a conversation that I was having with a client last week. They wanted to file bankruptcy, but they wanted to file a Chapter 7 bankruptcy. If they had to file a Chapter 13 bankruptcy, they did not want to file bankruptcy at all. And, of course, I'm going to give my input, give my advice, give my suggestions, but at the end of the day, the client controls. And so whether I think Chapter 13 is the better alternative or not, I will tell them. But at the end of the day, if they want to file a Chapter 7 or do not want to file at all if it's a Chapter 13, that is totally up to them. Once they take my advice, once they understand. What I don't want to have happen is a client that is misinformed and doesn't want to file bankruptcy because of some misinformation or some internet law that they found or something that they've talked about with other friends who've been in the same situation or same position. So, if someone's adamant about not filing a Chapter 13, then I won't force them to file the Chapter 13. But before they make that decision, I want them to understand that a lot of the truths that they believe about the Chapter 13 were, in fact, myths. And so that caused me to brainstorm a list of 13 things. Now, about 3 or 4 of these things were things that I discussed with my client that they actually said and thought were truths about Chapter 13 that were not. The rest of them I brainstormed, and so I wanted to provide these to you. Now, before I get too much further deeper into this week's episode, I did want to talk about our sponsor, Sam Cohen of Attorneys First Insurance. Sam provides professional liability insurance, which is also malpractice insurance or errors and omissions insurance for attorneys and title companies all over the country. Now, he's focusing on Texas and Florida right now, but he can write for almost any attorney or title company anywhere in the country. So if you are an attorney or title company and it's coming time for your malpractice to renew, please reach out to Sam. If you're a supporter of the show, a great way to show your support would be to refer an attorney or title company to Sam Cohen. The easiest way to reach him is sam@attorneysfirst.com or www.attorneysfirst.com. I would very, very much appreciate if you would refer. I refer as many people as I can to Sam. I've used Sam myself. He is a great resource of information. He's honest, and he will give you an apples-to-apples comparison of what do you have now versus what can he offer. And he won't quote you, and he won't try to gain your business if he can't compete with what you currently have. And so that would be a great way to support me and a great way to support the show. So what I wanted to do, though, is get into this concept of 13 myths about Chapter 13. So myth number 1, you have to dedicate every penny of extra income to your Chapter 13 plan. Now, this is a myth. You do not have to dedicate every penny. So, in other words, what we do within the Chapter 13 is we take a look at your budget. How much money's coming in, how much money's going out. If you have $100 left over at the end of the month, your payment doesn't have to be $100. It is possible that that payment could be less than $100. Now, here's the other issue, though, is within your budget, the trustee does allow for food. The trustee does allow an expense for recreation, magazines, newspapers, those types of things. So there is a possibility that, let's say your budget shows that you do have $100 left at the end of the month, but let's say the trustee allows you to have $100 part of your budget for magazines and entertainment. Well, all you got to do is spend less than $100 a month in magazines and entertainment, and you'll have a little bit of money left at the end of the month. But typically, the trustee will allow you to have, if your budget, and $100 is probably a bad example because for $100, we may be able to squeeze you into a Chapter 7. So let's say it's $400 or $500 a month. We may be able to get away with a Chapter 13 payment that is in the $300 range, depending on the circumstances of your case. And so the trustee and the judges are not so strict that every penny you make every month has to be dedicated to your Chapter 13 plan. We'll come up with a plan that'll have a set amount every month. If you happen to make a little bit more that month, or you happen to spend a little bit less that month, well, then you've got some extra money to do something with, to put into savings, to maybe send to the Chapter 13 trustee to pay down your bankruptcy plan a little bit quicker. But it is a myth to think or to say that the Chapter 13 trustee is going to require that every month you pay all of your disposable income to the Chapter 13 trustee. That is a myth. Along those same lines, this same client was saying to me last week, well, if we're in Chapter 13, we cannot take a vacation. Again, that is false. The trustee and the court and the budget do allow some money for recreation. So you could take a vacation. A client of mine, a former client of mine, actually he's a current Chapter 13 client of mine, actually has a couple of jet skis and I think a camper. And these are things that we disclosed within the bankruptcy case, and our particular judge allowed the debtor to confirm the bankruptcy plan and keep those items. Now, if this particular debtor was going away every week and was spending thousands and thousands of dollars on campgrounds and campsites, then yeah, the judge might have an issue, the trustee might have an issue. But to take one weekend a quarter, one weekend every 6 months, to take a week vacation once a year. The court understands this is fairly stressful. We're all people. We all need breaks. We all need mental breaks. We all need vacations. And so myth number 2 is that you cannot take a vacation, and that is absolutely false. Both the budget and the court will allow you to get away from time to time to manage your life during this Chapter 13 process. You are allowed to have a life in this Chapter 13 process. The other myth that I hear, the third myth that I hear a lot is, well, this is something that I have to dedicate the rest of my life to, and that is absolutely not true. The longest a Chapter 13 plan can run is 5 years. The shortest a Chapter 13 plan can run is 3 years. Now, granted, 3 years, 4 years, 5 years is a pretty long, a pretty substantial period of time, but there are some ways that we might be able to shortcut that a little bit, number one. And number two, even though it is 3 or 5 years, it is pretty much a drop in the bucket as far as a lot of us are concerned. I mean, think about where we were. As I record this now, we're in 2021. 3 years ago was 2018. What were you doing in 2018? 5 years ago was 2016. What were you doing in 2016? Now, it may seem a long while ago, but it went really quick in terms of what was I doing in 2016 versus what am I doing today. So even though it's something that feels like it's a long time, it feels like it could be a forever period of time, the maximum period of time for a Chapter 13 case is 5 years. The minimum period of time is 3 years. Now, on top of that, like I said before, if you have a little bit of extra money at the end of the month and you feel like not saving it, you can pay it to the Chapter 13 trustee. Now, be careful, because if your Chapter 13 payments are $400 a month and you're consistently paying the trustee $500, $600, $700 a month, then the trustee is going to question some of the items in your budget, and the trustee is basically going to say, well, if you can afford to pay $400, $500, $600 a month, then maybe you should be instead of your current payment. So what I typically suggest to clients is, if you've got 50 extra bucks, go ahead and pay it. If you've got 75 extra bucks this month, go ahead and pay it. If you've paid a little bit of extra this month and you have a little bit of extra next month, use it for something else. Put it away in savings. Use it to take the family out to dinner. Use it to take a weekend getaway. I wouldn't consistently pay more than the minimum monthly payment. But what you'll do as you make more than what you're required to pay, if you pay slightly more than your required Chapter 13 payment, over time you will pay down the Chapter 13 case faster. And so that is a great way to get out of it earlier. Now, there are some legal issues there that I think are a little bit beyond this episode that we can talk about if you have questions. But the myth is that you'll be stuck in Chapter 13 forever, and that's absolutely not true. Even though 5 years right now can feel like a long period of time, that's the maximum period of time that you would be in a Chapter 13. Myth number 4, the trustee can garnish my wages. That is absolutely not true. The trustee is not going to do that in a Chapter 13 case, or I think in a Chapter 7 case. Unless in a Chapter 7 maybe the trustee gets a judgment, but I digress. In a Chapter 13, there is no garnishment from the bankruptcy trustee. If you don't make your payments, the Chapter 13 trustee simply dismisses your case. Now, because of the bankruptcy stay, the creditors cannot garnish your wages either. So while you're in a Chapter 13 case, you are completely protected from any type of garnishment. Garnishment is not something that you have to worry about in a Chapter 13 case at all. So for that reason, myth number 4 is that you are subject to garnishment while in a Chapter 13. Myth number 5, you can use Chapter 13 as a delay tactic. Now, I hear this a ton, and here's the way that I hear this. We have a foreclosure sale coming. We just want to file a bare bones, meaning just the petition, none of the supporting schedules. We want to file a bare bones Chapter 13 case. Now, I personally do not like filing these on behalf of clients for a couple of reasons. They're a lot more difficult to file. They're a lot more costly to file. But the main reason I don't like filing it is I don't like using Chapter 13 simply as a delay tactic. Now, are there times where debtors will file a Chapter 13 case, get the bankruptcy stay, get the foreclosure sale canceled, and then dismiss the Chapter 13 case, forcing the bank to go back to the drawing board to get their sale rescheduled? Does it happen? Absolutely it happens. But it's not something that I would ever do intentionally, because it's also an argument that the debtor is filing in bad faith. And if the bankruptcy trustee or the United States trustee can prove that a debtor is filing in bad faith, or that an attorney assisted a debtor in filing in bad faith, there could be criminal penalties involved. So it's nothing that I like doing. It's nothing that I ever recommend doing. And so, no, it is a myth that you can file a Chapter 13 case, get the foreclosure sale stalled, and dismiss it. Or, put it more accurately, it's not a myth. It is actually something that you can do. It's just something that people believe is something good to do within a Chapter 13, and I disagree. If you're going to file the case. Make a good faith effort to have a Chapter 13 case. Make a good faith effort to complete your Chapter 13 case. Another myth number 6, is that you can't move during the pendency of a Chapter 13 case. Remember, I said it's a 3 to 5 year payment plan, and so a lot of people believe they cannot move, and that is false. Now, what we need to do in terms of moving is we need to determine, does the debtor own a home or rent a home? If the debtor owns a home and it's homestead property, then we need to get permission of the bankruptcy court to sell that house and potentially buy a new house. Now, if there's equity in that house that's being sold, the equity can transfer to the new house. But again, we need to get permission from the bankruptcy trustee and possibly permission from the court to sell the old house and then use that equity from the old house to buy a new house. Now, what if someone's moving out of town? Well, again, I think it's the same concept. We just need to get permission from the bankruptcy court. There's nothing that prohibits somebody from moving, whether it be to another part of the town, whether it be to another city, whether it be to another state. There's nothing that prohibits someone from moving. We just need to, number 1, get permission from the bankruptcy court if we're going to be selling a house. Number 2, we need to update the address of the debtor with the bankruptcy court so that notices go to the correct place. And number 3, the debtor still has to make payments. And if all of those things happen, then I think, yeah, it is possible to move during the pendency of a Chapter 13 case. Now, one thing I mentioned is if you have a home or a homestead, what if you're a renter? Well, I think the same thing. I think you need to get permission from the bankruptcy court to move, because you may be incurring an expense, a rent expense, that is greater than or less than what you currently pay in rent expense now, which may impact your budget. Plus, there's other costs that need to be accounted for, like moving costs, moving expenses, and other things like that. So, myth number 6 here is you cannot move during the course of a Chapter 13 case, and that is entirely false. It is entirely a myth. Similar to myth number 6, myth number 7, you cannot buy a new car. Now again, this is a myth, and let me explain why. If you need a new car, the bankruptcy court will support you buying a new car. Now, If you're leasing a car, the lease is probably going to come up during the term. It's probably going to expire during the term of the Chapter 13, and so you will need to buy a new car. Now, when I say new car, I don't mean brand new, current year model car. It could be, but typically what I'm talking about is a car that's new to you. So whether it's a brand new, fresh out of the box, so to speak, car, or whether it's a used car, pre-owned car, certified car that is new to you. That's what I'm talking about when I say new car. Now, again, with a new car, we need to run this by the trustee first. So we need to tell the trustee what are the terms. What is the trade-in value given for the old car that we're trading in? What is the purchase price of the new car? What's the down payment? How are you making that down payment? What's the interest rate? How many payments? What's the amount of the payments? The payments need to be something similar or less than what you currently pay. And in some cases, if what you pay is above what the means test allows you to pay, so call it about $560, give or take. If your payment's going to be above that amount for the car, the trustee may decline it regardless. So we want to make sure maybe we're coming down in price, coming down in options, coming down in value. Maybe if you have a BMW, you move to a Nissan or a Toyota. Maybe if you have an SUV, you move to a car. Again, drop in amenities, drop in features, drop the payment somehow, and in most cases, the trustee will let you finance a new car during a pending Chapter 13. Just remember, we need to get the trustee's permission first, and if the trustee refuses to give permission and we think it's a viable way to get a new car, we can always file a motion with the judge and ask the judge to overrule the trustee. But the myth here is you cannot buy a new car when you're in a Chapter 13, and that's wrong. You absolutely can. Myth number 8, the trustee is going to take all of my stuff. That's not true. That is a myth. Now, if we're in a Chapter 7, it may or may not be a myth. But in a Chapter 13, it absolutely is a myth, at least in the Tampa Bay area as far as I know. Now, I'm not speaking for every Chapter 13 trustee nationwide, but I know that in this area, and I would suspect in a lot of areas in the country, the trustee will put a value on your assets. And so if you have Great Aunt Edna's ring, which has a huge diamond in it and is worth $10,000, the Chapter 13 trustee is not going to necessarily take that ring away from you, but the Chapter 13 trustee is going to want to make sure that you're paying at least $10,000 worth of value to your unsecured creditors through the life of the plan, over the term of payments of the plan. And so it's not really a situation, I think it's a myth, because the trustee's not going to take your stuff, but the trustee is going to make sure that the value of that stuff is being paid to your creditors over the life of the plan. Now, this may not be an issue if your income supports a payment that is higher than that. So, remember I said, if you have a $10,000 ring that the trustee says, well, that money needs to be paid to the creditors over the life of the plan, but your budget supports a monthly payment of $500 a month. So $500 a month times 60 months is $30,000. Well, the trustee is going to get more by that $500 a month than they are by making you try to liquidate Great Aunt Edna's ring. And so in that situation, even though the value of the assets is relevant, it is less so because you make more than the value of your assets. You can afford to pay more than that to your creditors over time. Again, $500 a month for 60 months is $30,000 versus a $10,000 asset. You're probably not going to have to worry as much. We still need to report the value of that asset and report it accurately to the bankruptcy court, but it's not necessarily going to be as big a factor in determining what your monthly payments should be. Now, same scenario, if it's $50 a month that you can afford to pay, and again, this is a bad example because I think at $50 a month you might still be a Chapter 7, but if it's $50 a month, so 50 times 60 is only $3,000, in that situation, the trustee is going to say, well, yeah, that $10,000 ring, that value needs to be paid to your Chapter 13 creditors over the life of the plan. So we're going to take $10,000, we're going to divide it by 60, and that's going to be what your monthly payment is to your unsecured creditors. Now, myth number 9 isn't necessarily a myth. It's just something that's very often misunderstood in Chapter 13 cases. So remember I said earlier, myth number one, the trustee wants all my disposable income. Well, that typically is something that's analyzed on an annual basis. So every year, the Chapter 13 code and the Chapter 13 rules here require that you submit your tax returns to the trustee annually. So when you file them with the IRS, you also have to send them to the Chapter 13 trustee. And that is one reason so the trustee can determine, well, what was your income this year based on last year? If your income goes up, your Chapter 13 payments may go up. Now again, not dollar for dollar. So if you made $1,200 more this year than last year, the trustee is not necessarily going to suggest or recommend that your payments go up $100 a month. It doesn't necessarily work that way, but the trustee could ask that your payments go up slightly to reflect your increased income. Now, the opposite side of that coin is also true. If your income has gone down, we can file a motion to modify the plan and downward adjust the monthly payments to the trustee because of a drop in income. Now, again, I don't know that the trustee and the court are going to let us get away with a dollar for dollar decrease, but that is something that we can do. Now, one of the other reasons the trustee wants your tax return is to see, do you owe taxes or are you getting a refund? And if you're getting a refund, that refund needs to be paid in most cases to the Chapter 13 trustee. Now, again, it needs to be paid to the Chapter 13 trustee, but it is not a payment towards your monthly payments. So let's say your monthly payments are $500 a month, and let's say you get a $2,000 refund. That doesn't mean that you get to take 4 months off after paying that refund to the trustee. What that means is that you continue to make your $500 payments to the trustee, and you've just paid an extra $2,000 to the trustee to pay to unsecured creditors. So if you were paying 20% to your unsecured creditors before, after that $2,000 payment comes in, maybe you're paying 21% because that's extra money. Now, this has been fleshed out in a lot of litigation. It's been fleshed out between debtors' attorneys and creditors' attorneys in the court. And the concept is that the refund is really just unused wages or wages that have been sitting with the federal government that have been paid back to you. In other words, if you did not receive that $2,000 refund, let's say you received a refund of $0, that $2,000 would have been spread into your paychecks, meaning you would have taken home more money at the end of every month, at the end of every paycheck. And so for that reason, tax refunds have to be paid to the trustee, and they are not something that pays down what you would otherwise owe to the bankruptcy trustee, unless potentially you're in a plan that pays 100% to the unsecured creditors, because you're not going to be paying back more than what you owe. And so if you're in a bankruptcy plan that pays back 100% because of the value of your assets, because of the value of your debt, because of the value of your monthly income, something like that, then yeah, every penny you pay to the trustee is going to pay down what you owe to your unsecured creditors. And so, yeah, maybe in that case, the refund will pay down the debt a little bit faster. But in most cases, that refund is just going to be added to what you owe to your creditors, added in. So you'll be paying a little bit more from a percentage perspective to your unsecured creditors. The myth here is people don't know or don't recall, even though we remind them of it, they don't know or they don't recall that they got to send their refunds to the trustee every year and send their tax returns to the trustee every year. So if you are a client of ours, or if you become a client of ours, or if you're currently in a Chapter 13, every time you file your tax return, send a copy to your attorney to send to the bankruptcy trustee. If you get a refund, hold on to that refund until you hear from your attorney. Now, there are some circumstances where we can apply to the bankruptcy trustee to keep the refund if there are some unexpected expenses that pop up. Unexpected medical expenses, unexpected repair expenses, refrigerator goes out, air conditioner goes out. Unexpected type expenses. For things like that, we can ask the trustee to hang on, if we can hang on to the refund instead of paying it. If it's something that's truly unexpected, in a majority of cases, in a great majority of the cases here in Tampa Bay, the trustees will let us keep it. But because of the confusion over tax returns and tax refunds, I wanted to include this as myth number 9. Now, myth number 10. all of my debt gets repaid. Now, this could be true in some cases, but is not necessarily true in every case. And so what do I mean there? Well, the way that we calculate what your payments will be to the Chapter 13 trustee is we take a look at what does the means test provide that you can pay, or what does your budget provide that you can pay, and what do you have in assets. Whichever one of those produces the highest payout to the unsecured creditors is the test we're going to use. We then compare that against what is your overall debt, and that's how we come up with the percentage that you're supposed to pay. Now, again, I'm coming at this from a 50,000-foot theoretical view. But let's take in my example, I made this example earlier in this episode, an extra $500 a month over a 60-month bankruptcy plan is going to be $30,000. If you have $20,000 in debt, you're going to repay 100% of what you owe because your budget supports that you can pay back $30,000 and you only owe $20,000. Now, if you owe $60,000, you're only going to pay 50% of what you owe. Again, your budget supports that you can pay $30,000 over the life of the bankruptcy plan. Your debt is $60,000. 30 divided by 60 is 50%. If you have $120,000 in debt, you're going to pay back a quarter of what you owe. And again, I'm not getting into right now, is it IRS? Is it student loans? Is it medical? Is it credit? I'm just coming at it from a 50,000-foot overview. If you have the ability to pay back $30,000 over the life of a bankruptcy plan and your total debt's $120,000, then you're paying back a quarter of what you owe, theoretically. So again, the trustee and the judge are not going to force you to pay back everything. They're going to force you to pay back what you can afford to pay. You're not ever going to pay back more than what you owe, and it doesn't always have to be a full repayment. Now, there's one caveat to that. In my earlier example, somebody that makes $30,000 a year that owes $20,000, well, they have the ability to pay more than $20,000. So in a situation like that, that is the one situation where the trustee may apply some interest component, 3 or 4 or 5% interest. Not a lot, but the trustee may impose some interest component to what you pay. So in an example like that, yeah, you would pay back slightly more than 100% of what you owe because you can afford to pay so much more than what you owe. But that's a very rare situation in my experience. Myth number 11. The creditors have to approve the bankruptcy plan. Now, a couple things. Number one, that's not true in a Chapter 13 in the way that I'm thinking. Now, in a Chapter 11, it is true. There's creditors committees, and they have to approve of the bankruptcy plan, but that not in a Chapter 13. In a Chapter 13, typically the creditors don't get the ability to approve the plan. Now, they can object to the plan, and if the creditor objects to the plan, then that has to be hashed out with the creditor before the plan can be confirmed and proceed. But there is no requirement within the Chapter 13 process that the creditor approve the plan. Now, what are some things they could object to? Maybe they object to their treatment. We're treating them as unsecured and they're really secured. We're proposing to cram down or eliminate their debt where they think they're a legitimate debt against homestead. Maybe the creditor objects based on one of these bad faith criteria. Maybe the creditor objects because they said you've filed too many times. Something like that. So creditors do have the ability to object to a bankruptcy plan, but it's not like they have to approve the plan. So if they object to the plan, we try to determine what is the basis of your objection. If we can resolve it, we resolve it. If not, we duke it out in front of the judge. If the objection is overruled, then the plan is confirmed. If the objection is sustained, then we have to figure out the treatment of that creditor if we want the plan to continue. But that's myth number 11. Myth number 12, I will lose my home and cars. Now, this is very similar to myth number 8, which is the trustee is going to take my stuff, but I wanted to include homes and cars specifically because of their secured creditor status. So we used to have a Chapter 13 trustee here in Tampa Bay that had a very simple saying: if you want to stay, you've got to pay. And so a lot of times what I will tell clients is if you want to keep your house, if you want to keep your car in a Chapter 13 case, you have to keep paying for those items. Now, if you are behind, there is a process within Chapter 13 to use the Chapter 13 to catch up on the arrears. And so Chapter 13 is a great way to avoid foreclosure. Chapter 13 is a great way to avoid a car repossession. But again, 50,000-foot overview. It's a myth because the trustee is not going to take your home or your car away from you, especially in Florida where homes are exempt. The trustee is not going to take your home away from you. Now, the creditors might if you don't pay for the asset. So again, if you want to keep your house, if you want to keep your car, you must continue to pay for those things. Now, if this is something you're worried about, again, get with your Chapter 13 attorney. If you don't have an attorney, get an attorney. Maybe myth 13 and a half here is that attorneys cost too much. I can tell you that's not true because we can help you weed through some of these field landmines here. But, again, I'm sorry to digress a little bit. If you want to keep your house, if you want to keep your car in a Chapter 13, you really only need to pay for it and work with your attorney and work with your creditor if you're behind to keep those assets. But it is a myth. It is myth number 12 that the trustee is going to take away your house or your car. Last myth about Chapter 13, your credit gets destroyed. Now, a couple of things here. First, I believe that's a myth because your credit will recover. It will always recover. Once you're on the other side of this Chapter 13, your credit will recover. During the pendency of the Chapter 13, you can print out your payment history and show any creditor that you have a successful payment history of however many payments in a row. Plus, when you're coming to me to talk about a Chapter 13, you've probably fallen behind on some payments anyway. You're probably getting sued by at least one or two creditors anyway. So your credit's already taken a beating. Chapter 13 is not going to make your credit any worse than what it already is. And in fact, when you're faced with a foreclosure, if the house actually gets foreclosed and you lose the house, then that's going to damage your credit a lot more than a Chapter 13. Now, between 13 and 7 I think is the better one. Your credit will recover after 7 years from a Chapter 7, after 10 years from a Chapter 13, plus you've got to enter that payment plan length in there as well. But know that your credit will recover, and also know that the bankruptcy will not impact your credit for that full 7-year or 10-year term. If you get foreclosed, good luck buying a house, ever. If you go through a Chapter 13, your credit will recover at some point in time enough that you can buy a new house. And again, when most people come to see me for Chapter 13, their credit is already smashed. So the Chapter 13 really isn't going to do any more damage than what has led them to me to begin with. So those are my 13 myths about Chapter 13. Did I leave any out? Or do you believe something about Chapter 13 that you can email me that maybe I can, in a future episode, or maybe even in an email to you or a blog post or whatever, dispel as a myth? What do you believe to be true about Chapter 13? So let me know, and I can tell you if it's a myth or if it's a truth. But again, just to summarize, the 13 myths about Chapter 13 are, number 1, I have to pay all my disposable income to the Chapter 13 trustee. Number 2, I cannot take a vacation. Number 3, the Chapter 13 lasts forever. Number 4, the trustee can garnish my wages. Number 5, Chapter 13 can be used just as a delay tactic. Number 6, I can't move during a Chapter 13. Number 7, I can't buy a new car. Number 8, the trustee will take all of my stuff. Number 9, the trustee does not need to know about my tax refund or my tax return. Number 10, all my debt gets repaid in a Chapter 13. Number 11, my creditors have to approve my Chapter 13 bankruptcy. Number 12, I will lose my home and cars. Number 13, my credit is destroyed. So that's it. 13 myths about Chapter 13. I hope you enjoyed this week's episode of the Crushing Debt Podcast. I hope that at the end of the month you have more money, rather than at the end of the money you have more month. That'll do it for this week's episode, and I look forward to talking to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.